do or you do not agree that these are the violations?
Correct. That I agree that is how she sees it.
We are on the record in the 13th Judicial District, District Court of Greenwood County, Kansas. This matter comes on for motion to revoke probation in 2 cases. And Mr. Favre, are there any announcements? Does your client wish for a hearing?
So there is, Judge. Speaking to Ms. Blades, at this time, she's requesting for a new attorney to be appointed, and she's requesting for a continuance so that new attorney can be appointed.
Ms. Blades, you have anything you want to say on your own behalf?
Yes, Your Honor. I have spent enough time in here for being a good mom, and I need a better option than that. I mean, third party contact was not my fault, and the fact that a guy that I was seeing texted the child, and so I'm just hands down.
Hold on. So you basically don't like what Mr. Favre has advised you or told you?
I just need more time to find new options, I guess. I've tried. I've done everything that I can, and I am depressed at this point, and I just need a continuance or whatever, because
Okay, well, let me tell you what I think you're saying. I think I'm hearing you say you just don't like the results he's getting you.
It's not that. It's just, I just need a continuance. I do. I need a continuance.
For what purpose?
To hire new counsel.
Well, these cases have been going for a couple of years now. At least one of them has been going for a couple of years. The other one is earlier this year. I've always found Mr. Favre to be a very competent, exceptionally competent attorney, very diligent in fighting for his clients' rights. Now, I'm not prejudging you, but sometimes the clients don't give the attorneys enough to work with to get the results the clients work. That may or may not, or want. That may or may not have anything to do with why you're asking to have him replaced. I don't know. But I'm going to deny the request unless I have some good reason to grant it. But just because you don't like the results you've had to date, that's not going to work.
Well, I also want to continue, Your Honor, so that I can possibly make the option to hire my own attorney.
Well, you've always told me you didn't have a job or you didn't have the money to hire an attorney. What's changed since the last time you applied for court appointed?
Maybe I have a friend that'll help me. I mean, I can try and call out and try and make this decision. I'm trying to work with my options here. I'm stuck in a jail.
Well, you're stuck in the jail because there was a warrant issued to show cause why your probation should not be revoked. But let's focus on whether or not you need a new attorney. And I don't believe you do.
Do I have the option of having it reinstated?
Well, I can't tell you that. I don't know where we are on this. I can tell you you have the right to challenge the allegations and say they're not true, that you have not violated your probation. We can go to an evidentiary hearing and Ms. Gillette can present the evidence. Ms. Morgan is here to testify to what she has alleged in the request. Mr. Favre is here to help you to the best of his ability to show that you haven't violated or to put doubt in the testimony. But ultimately, I have the responsibility of hearing the evidence, both the state's and yours, if you wish to present any. And I have to determine, did you violate or did you not? If you didn't, then I'm back on your merry way to probation. If you did violate, then I have to decide what to do about it. Do I reinstate you? Do I put you in jail to finish your sentence? Do I do some combination like we did the last time you were here on a warrant to show cause, where you did, I believe, a 90-day sanction, and then I put you back on for a year? But that's just going to depend on what I hear.
Okay, can we break out for a minute and let me visit with Favre then for just one more second, Your Honor, and then we'll get back together.
You can take whatever time you want. But again, if I'm hearing you correctly, you want a new attorney because you don't like the results you've had to date.
No, it doesn't have anything to do with that. I just wanted a little more time to think about my options since these were just presented. But if I could speak with Favre, because he's put forth the effort.
We generally address folks by Mr. and Miss. Well, this was filed October 28th of 25, and it is now December 16th of 25, and you have not had enough time to think about your options and your opinion. Is that correct?
Well, I haven't been able to speak with Mr. Favre. I've tried to call, I've had other people call, but we haven't had a chance to get together because I know that he's a busy man. So I'm just being
You're in
respectful.
jail, correct?
Yeah.
Yeah, you've been in jail. I know at one point I ordered a no bond hold because you kept failing to come to court. I don't know if that's been this issue, but that's been a problem, I'm sure. All right, yes, you certainly can have a breakout room to talk to your attorney.
Thank
Mr.
you.
Favre, I'm denying any requests at this point to allow you to withdraw.
Thank you, Judge.
Ms. Blades, have you had enough time to talk to your attorney?
Your Honor.
Yes?
Yes, yes, ma'am.
And do you have any questions of what we're doing here today that you want to address with the court?
No, I just think that we were talking about if I've done something in order to, since it's only been a month and I've had some issues with being away from everything and not having a way out here and Lyon County not taking on my case and then having a dirty UA, maybe
Ginger.
if I've done something wrong, treatment
Ginger.
of some sort. So I think
Ginger.
that's where we were headed with it, but I'll let him.
I was gonna say, Ms. Blades, he is appointed to represent you. I know he's very experienced. Do you want to let him do that, or are you wanting to represent yourself?
Oh, I just thought you'd asked me what we were. Yeah.
I asked you if you had any questions for me about why
Oh.
we're here today.
Oh, no. No, Your Honor, I'm sorry.
All right, you need any more time to visit with Mr. Favre about that?
No, ma'am.
All right, and are you ready to proceed on the warrant to show cause why your probation should not be revoked?
Yes, ma'am.
Judge, no, hold on. I apologize. We have a change in announcement. Ms. Blades will be waiving her right to an evidentiary hearing at this time and stipulating to the violations.
All right, then let me visit with you, Ms. Blades, again. Do you understand what the allegations are against you in these motions? And let me go over them with you just in case, so that we make a record that you understand what it is that the state is alleging. They are alleging that your probation should be revoked because, first of all, they say you failed to pay court cost fines as directed with a balance of $679. Your last payment on 2/26 of 25 for $134. I'm not going to ask you how you respond to that, but do you understand that that is what they're saying one of your violations is?
Yes, ma'am. And I had,
Don't answer that just
Okay.
yet. You've got an attorney to help you. Do you understand number two? They're saying you failed to report to your probation officer as required on 10/21/25 and 10/28/25. Do you understand that? Not a response, but do you understand they are saying that's a violation of your probation?
yes, ma'am.
Okay, so they're saying that you failed to report and that that's a violation of your probation. Then they're also saying number three, that you violated your probation by committing new laws in the city of Emporia with criminal trespass now pending. On 10/28/25, the defendant participated in a urine analysis and was positive for methamphetamine, amphetamine, alcohol, and THC. The defendant has pending case in Emporia Municipal Court for alleged charges for criminal trespass. On 9/30 of 2025, the defendant reported to this officer that the criminal trespass happened at a known bar in Emporia, Kansas, which is in violation of probation. This officer would request for the defendant's probation be revoked as she is not amenable to probation. Now, and then this is signed by a motion to revoke by Jill Gillette, but it's based on the original affidavit of your probation officer, Jessica Morgan, and it would be Miss Morgan when it's referring to this officer. Do you understand what I've just read?
Yes, ma'am.
That you violated the order not to enter any business whose primary source of income is for the sale of alcohol, that you violated the order not to associate with alcoholics, illegal drug users, or people who make alcohol and or illegal drugs available. And that's based on the allegations that I read to you from the other case. Do you need to speak to Mr. Favre any further about anything I've just gone over with you?
No, we've already spoke, Your Honor. I think that he's willing to just speak with you, I guess, on
Okay. All
however.
right. Ms. Blades, do I understand correctly that you understand you have a right to challenge these allegations and to require the state to present evidence?
Yes, ma'am.
But you also have the right to waive your right to hearing and say, no, Ms. Morgan doesn't have to testify. That's what she would testify to.
Yeah,
And-
no, she doesn't have to testify. I just had wanted to request treatment. Is
All right, so, okay, so you're
Information.
waiving you understand you have a right to hearing and you're waiving your right to that hearing today? The
Yes.
evidentiary portion?
Mhm.
All right. And then the next step is, do you stipulate, that is, agree to these allegations? You can do that, and we can avoid the evidentiary hearing, or we can have the evidentiary hearing. But if you agree that this is what the evidence would show, there's no need to go on with the hearing unless you want to.
I think we had discussed that. I think it's Favre's time.
You want Mr. Favre to address that? Mr. Favre, I don't know what that means. Is she stipulating that she did violate, but she wants you to present reasons why, for disposition, basically?
Yeah.
Judge, we went over that a lot, and she is, from what I understand, waiving her right to an evidentiary hearing, stipulating to the allegations listed in the warrant to show cause, and we're ready to proceed to disposition.
All right. Is anybody making you give up your right to this hearing and this testimony, Ms. Blades?
No, Your Honor. I'm just ready to get it all settled.
All right. Is anyone making you agree that the evidence would show what's listed in this motion to revoke probation?
No.
Okay.
Oh,
but you
what
do-
did you just ask me? I'm sorry. What did you just say?
Okay. All right. Do you agree that the testimony in this case would show the violations alleged in the motion that I went over with you? Do you agree that that's what Ms. Morgan would testify to, most likely?
That may be her side, but I remember it differently. But I mean, I can't prove that I called her
Okay.
on a weekly basis and all of those things, you know, whenever I had
So you
contacted her
don't
repeatedly
agree,
because I didn't have a car. So
you do or you do not agree that these are the violations?
correct. That I agree that that is how she sees it.
All right. And that's what the evidence would show if we went to a hearing.
Yeah, most likely, Your Honor. Mhm.
And you through your attorney would have the right to cross-examine that, but you wish to waive that hearing and proceed to disposition, and that's where Mr. Favre would start argument.
Yes,
Are we
ma'am.
in agreement? Do we understand that?
Yes, ma'am.
All right. And you've talked about this with Mr. Favre, and you have agreed with your attorney. You want to waive your right to hearing and stipulate to the violations, or at least take a no contest to the violations.
Basically, yes, Your Honor.
Well, I'm going to accept the defendant's waiver of hearing, and I'll accept more of a, I don't know that I'm hearing exactly a stipulation to the allegations as being true, but she at least stipulates that's what the testimony would be. And she said that's what Miss Morgan sees it as. She may not see it that way, but she thinks Miss Morgan does, and that's what Miss Morgan would testify to. Did I say that right, Miss Blades?
Yes, Your Honor.
I do find the defendant has violated her probation as alleged in the motion to revoke probation and the affidavit in support of that motion. Now I'll proceed to disposition, which means what should I do about the fact that she's violated her probation a second time around? Ms. Blades, do you take the same position in both cases, 24 CR 122 and 25 CR 69? That's what the evidence would show?
In the second one, I didn't have a vehicle, so
I understand. And
okay.
Mr. Favre is going to talk
and they
about.
didn't take it on
Okay.
my case in Lane County. And I had assumed that that was going to be the option when I had agreed to probation in the first place. They had said that they were going to have it moved to Lane County so that I was able to
All right,
abide by
let's stop.
probation.
Mr. Favre, do you want to go ahead and let her testify?
I'd rather not, Judge. I think we're good. I think we'll just have Ms. Gillette make her recommendations, and then we'll follow after.
All right. Well, I find in both cases that the same information is true and correct, with the exception that she only had prior revocation in the one case and not in the other, in the later one. Ms. Gillette, recommendations for disposition on these violations?
Judge, it's going to be our recommendation that she serve her underlying. Ms. Blades is not amenable to probation. I don't believe that she has afforded herself a treatment in either case. It's been a lot of not taking responsibility. If you don't have a car, you make arrangements for rides. If you are testing positive, you ask your CSO for treatment before you come in here. You make an admission and you say yes. Ms. Blades, I have added up her jail credit. And I have it all compiled. Her underlings are each 12 months. I believe Mr. Favre is probably going to ask for a reduced sentence if the court says to serve her underlying. I went back and looked at the cases as to whether they were concurrent or consecutive. I don't have notes in the 25 CR 69 case that it was consecutive to the prior case. If they ran concurrent, it would currently have a 12-month underlying if they're concurrent there. And she had 20 days of jail credit on her original. Mr. Favre and I were talking earlier, and I thought it was 145, but it's actually 148 days.
Well, let's look at that. There was 20 originally at sentencing,
Mhm.
and then the next journal entry, there was a specific amount put in there.
She had 90 days to do, and she had 87 days of jail credit and should have had 3 more days. It was 520. She had 11 days, 5/3/25 to 5/14/25 on the one case. And then she had 5/27/25 to 8/12/25. Then she had 8 of that is the full 30 days or the 90 days.
All right, so the 90 days is between the two.
Yeah, she had 145.
So it wasn't concurrent.
So she had then 11/19/25 to 12/16/25. That's 27 days for a total of 145 days. And I have all of that written down. I would just ask that she serve her underlying. And if Mr. Favre asks for a reduced sentence, I'd leave it up to the court. But I just don't feel that she's going to be successful back on probation with all of the issues. Conditions of probation are don't be in a bar, and don't be in a bar that you have a no trespass order on. And then testing positive for amphetamine, methamphetamine, THC, and alcohol. Those are all substances you're not to be using. And she was just here, went right out and did it again. So that's why I don't feel that probation would be successful if she was placed on any kind of supervision.
Depressed without my family.
And she was on probation in the 24 case when she was convicted in the 25 case, yes?
Yes.
All right, Mr. Favre, your position.
Yes, so Judge, I think just to concur with Ms. Gillette's framing, I think we're looking at about a 12-month underlying total because I think both cases are concurrent. She has 145 days. I agree with that. 148 days. I'm sorry. I agree with that math. Speaking to Ms. Blades, there's a lot of things going on in her life that are kind of contributing factors. And I think I would point out that, first of all, she came into this with almost no criminal history. She doesn't have any prior felonies. She obviously has some substance abuse issues. She's not a Greenwood County resident. She's relocated to Emporia. There was some issue with transferring the probation to Emporia that I don't quite understand, and I think that's part of the reason why there was communication issues on reporting. Now, I'm not saying that to just mitigate all of her responsibility, but I think that the note from Miss Morgan notes that she was calling at different times, showing up late. I think part of that confusion is just being out of county, right? I think she was making efforts, and as we all know, people can just choose to drop off the radar, and Miss Blades didn't. She is obviously having behaviors that are substance abuse affected, being in bars, poor reporting, testing positive. So Ms. Blades would like me to ask that she be given one more opportunity at probation. She's been in this time since November, I think 17th. She was arrested in Lyon County. She'd like one more opportunity at probation. It is her first time up technically on 25 CR 69, but that was picked up while she was on 24 CR 122. She'd like another opportunity at probation with court order treatment and Miss Morgan to hopefully get an evaluation, help her, and get set up for treatment. That's her request. I think it may not be a bad option, as well as mental health. I have some concerns about her mental health issues as well, not to the extent of like worrying about a competency per se, but I think there's some mental health assistance that could be beneficial there. So that's our request, reinstatement with, and maybe the answer is to have her stay in until a bed can be arranged by Miss Morgan. That's our request. In the alternative, if the court is just not willing to give her another opportunity at probation, we'd ask the court to consider mitigating her sentence based on those factors to something closer to 8 months. She's already done almost 5. She'd have an additional 3 to do. As I said, she has no ties to this county anymore. So we asked the court to consider letting her move on quickly and get back to Lyon County.
Well, I became involved with this case, as you all may recall, sometime in 2024. There was a concern that she was taking her young child, very young, to a convenience store and offering to have sexual relations with that child and customers. Ms. Gillette, did Lyon County ever file that initial case?
I'm not aware if they have filed any charges.
Well, because of allegations, she had no contact orders put on her in the first case, 24 CR 122. She violated those and was sentenced, given the privilege of probation. Some people think it's a right, but anyway, she was put on probation with certain conditions, one of which was to continue with the no contact orders. While she was on that probation, she went out and got another conviction, the 25 case, for having contact that she was ordered not to have. The complaint that started all of this, these 2 cases, was June 13th of 24. And I am going to take a little extra time because I think the history in this is very important. The journal entry of plea and sentencing, and this is in the 24 CR 122, was filed November 28th of 24, just barely a year ago. The journal entry of plea and sentencing, the charges had been amended down to 1 count of misdemeanor violation of a protection order, a Class A. It was amended down, so she had the benefit of having some felony orders amended down to misdemeanor, 1 misdemeanor, and she was put on probation. Adult Court Services Supervision ordered, again, November 19th, 2024, and the plea and sentencing filed November 28th, 24. That was the journal entry filed. The first affidavit for request of probation came March 28th, some 4 or 5 months later. Request that she had violated. A warrant to show cause followed, motion to revoke probation accompanying it. I see a warrant to show cause return filed May 6th of 25. So it took that long to get that warrant served apparently and returned. There was a probation for revocation hearing filed August 19th of 2025. I'll call that up. On August 12th of 2025 in 24 CR 122, there was a revocation hearing for violation of probations, which were found. And at that time, the defendant was ordered to do a 90-day jail sanction with credit for time served, and she was extended for 12 months from that date. October 30th of 2025, just 2 months later, there was another motion to revoke probation filed. That's again in the 24 CR 122 case, alleging the new violations that we've been talking about today. Now, moving on to the 25 case that we're also here on today, a new charge, violation of protection orders, again was filed. I'm sorry, October 28th. So by October 28th, she'd already, in that short of time, between the 19th and the 28th, she was already getting requests for revocation of probation. She was to go down to see her probation office, and she didn't. She was late. The warrant to show cause October 29th. The official motion filed by Ms. Gillette was October 30th. And so, no, she was not on probation very long in the 25 CR 69 case before the request was made. And I think she kind of intimated about that a while ago. But the thing is, she's been under court supervision all this time, and it doesn't seem to be getting through to her. She was told not to have contact with certain people. She violated that quickly. She was put on bond and or probation, told don't have contact. She did it again. She's not just having small violations. She's having a new case in Greenwood County. Granted, that has not been resolved yet, but She did tell her probation officer, Miss Morgan, that she had been arrested for trespassing in a bar where she was not supposed to be as part of her probation. I tend to agree with what I've heard from the state that the defendant is not amenable to probation. I think we can keep putting her back on it and maybe even having her do a 90-day dip in the jail, but I think she's just going to keep violating. So at this time, I do revoke her probation in both cases. And I'm going to order that she serve the balance of her sentences in each case with credit for any and all time she's already earned to date. And the jail will need to figure that. They've probably already figured that for Miss Gillette, but they'll need to officially figure that for the journal entry. And I haven't heard any good reasons why I should reduce that sentence at this point in either case.
So what is that? How long does that give me?
It's an underlying sentence of 12 months, Ginger, minus time served.
Okay.
Right.
All right. Thank you, Your Honor.
And since the case journal entries don't address whether they run concurrent or consecutive, and one was committed while the other was pending, case law will have to direct that.
Thank you.
Thank
Have a
you.
nice day.
You too. We are in recess.
Thank you.
You're welcome.